Hello everyone. Today we will discuss section 10 of CPC, that is res subjudice. Now before introducing this topic, I want you people to just think about this hypothetical situation where in a country nobody is obeying the judgment and decree of court, or it is not even mandatory to obey the judgment and decree of court. Now what is happening in this country? So if there's a dispute between A and B, the court has passed a judgment which is against B. Now B is again instituting a suit in a different court of same level. Okay, that court also passed a decree, but this time this is against A. So A got disappointed and now he is going for the third institution of a suit in a different court but of same jurisdiction and same level. And then this time B got the decree against him. So B going to institute the suit for the fourth time, and by like this suit is like never ending process. The thing is, in order to save from such situation, we have this maxim that in the interest of the state and in the interest of the public, there should be an end to litigation. That if the parties or if the people will not obey the decision or decree of the court, then obviously people will go to forums after forums just to win the case, not for justice but to win the case. The thing is, we know that a party may get disappointed with the judgment. So if you are disappointed, go to the appeal. First appeal, second appeal. But don't just institute the suit afresh. There's a difference between that. So our law understands this situation that there may be a time when the judgment was not so correct or the party has not presented a case that good, and the right party, the really right party or innocent party got the judgment against him. But in this case, if you are so disappointed and you know that you are the right person and the judgment should be in favor of you, you should go to appeal. And then you can go for first appeal, second appeal. But finally, there should be an end to litigation. It should never be a never-ending process. Understand? Now, with this pretext and also with this object to put an end to this litigation, to any litigation, we have incorporated Section 10 in Code of Civil Procedure 1908. So, to start this topic, firstly, let me read Section 10. So, what is Section 10? Section 10 is, no court shall proceed with the trial. Please underline proceed with the trial. No court shall proceed with the trial of any suit. Underline suit. No court shall proceed with the trial of any suit in which the matter in issue, underline matter in issue, in which the matter in issue is also directly and substantially, underline this, directly and substantially in issue in a previously instituted suit, underline previously instituted suit, between the same parties, sixth ingredient, under the same title, seventh ingredient, where such suit is pending, eighth ingredient, that is the previously instituted suit is pending, eighth ingredient, in the same or any court having jurisdiction, ninth ingredient. Okay, having jurisdiction. So this section has 9 ingredients, that is, no court shall proceed with the trial of any suit in which the matter in issue is directly or substantially in question, is related to a previously instituted suit between the same parties under same title in any Indian court having jurisdiction. So these are the 9 essential ingredient of section number 10. Now let's start discussion on section 10. Firstly, the section says that the court shall not proceed with the trial of any suit. Now what is this suit? So with the help of explanation and also with the help of many judgments and also with the help of textbook, we have understood that suit also includes appeal. And suit does not include application and complaint. So this section applies only when there is either suit or appeal but not application and complaint. Understood? Next one is that the matter in issue. Matter in issue directly and substantially. What is this directly and substantially? It's not written here. Matter in issue, this one, matter in issue. This section is saying that either the matter directly or substantially in issue is already there in the previously instituted suit. Understanding? Now section 10 says that if the entire matter which has been which is the subject matter of the previously instituted suit, if the entire matter is the same, then section 10 applies. But if there is overlapping of matters, okay, if there is only overlapping of matters between this freshly instituted suit and the previously instituted suit, then section 10 does not apply. Understanding? That is, for example, A and B has a dispute. And what is the dispute? A is saying that B has taken wrongful possession of his building and is collecting rent also for almost 5 years. And now I have given this building to B just as a tenant, that you can be there, you give rent to me, and also on my behalf collect the rent from others also and transfer it to me. So this was our original contract. B was my tenant and I gave him this right to just collect rent from everyone and collectively transfer it to me. Understanding? But B gradually started, B gradually pretended that he is the owner and collected all the rents from all the tenants and never gave any of the rent to A. Now this is the cause of action. That is, the right of A to take the proceeds of rent has been violated by B. Understood? So, A came to the court, maybe in the court of Delhi. That is, my building is in Delhi and B is in Delhi. So, that's why A approached Delhi court and filed a plaint, instituted a suit saying that B has not given me rent proceeding for 5 years. Okay, this is the first suit. Now, after 1 year or 1.5 years, when this case was still pending in Delhi High Court, now A is going to Haryana District Court. Haryana में किसी भी एक you can say रुड़की में, है ना? In any of the other district court of Haryana, that person went and registered another suit, and in this suit A is saying that B has taken wrongful possession of the building of which A is the owner and is not giving the rent of all the tenant to him. In the earlier suit only the rent of B, है ना? But in this suit all the rent, the entire rent amount collected from all the tenants, this B is not giving, and also in ejectment. That is, I want B to eject my or just go away from my building. ठीक है? So the previously instituted suit had matter in issue, that is B is not giving rent to A. But in the second suit, the matter in issue is, that is B is not giving those rent which is collected by those people, है ना, which is collected from those tenants, and also B is not vacating the building. So this suit has different matter in issue, and the previously instituted suit, although they are part of kind of same transaction, but It's a different matter in issue here. Now the thing is, the court in the situation of overlapping, ठीक है, in the situation of overlapping are not bound to apply section 10. They may proceed with the trial. ठीक है. So if the entire matter is same, then section 10 definitely applies. There is no exception. ठीक है. But if the matter overlaps, matter in issue overlaps, then the court may say that we will proceed with the trial. ठीक है. So this is about matter in issue. Then same party, obviously same party होना चाहिए, under same title होना चाहिए. These two things, that is same party same title, we will discuss more in section 11. So अभी इतना ही समझो, same party same title. Anyways, I am going to discuss it in the next video. And then also, that is, what is the concept of foreign court in section 10? The thing is, the court is only barred, or the court will apply section 10 only when the previously instituted suit is in Indian court having jurisdiction. If the previously instituted suit is in some foreign court, court of Afghanistan, court of Russia, court of America, then Indian court will not put a section 10 on this suit. ठीक है? Court will proceed with the trial. Understanding? So if the previously instituted suit is in some foreign court, section 10 is not applicable. It should be Indian court having jurisdiction. Then also, that is, section 10 bars only trial of the suit, not institution of the suit. So for example, if you are coming to a court, है ना, at the outset of the case, I don't know whether this kind of subject matter in issue between both of you under the same title is already pending or not. I am not aware of this as a court. So I asked you, ठीक है, लिख दो, will proceed with this. Okay. Now what happened? So the court got to know eventually that the same matter is proceeding somewhere, is pending somewhere else. है ना? That court is listening over this dispute. So what the court will say? I am going this. Now there will be a hold or pause on this trial of the suit. It will not dismiss your suit. It will not reject your suit. But just it will not proceed with your trial. Okay. So it is not like section 10 bars the institution of suit. You can come and institute your suit to this court, but it bars the trial of the suit. That is, the court will not listen the matter. Trial will not proceed. ठीक है? So this is the difference. Now the stay on that particular suit which has been previously instituted in some other court, Indian court having jurisdiction, the stay can be put at any stage. So whenever the judge got to know that, oh, you people, you already have registered this in somewhere else and again coming to me, whenever the court comes to know about this, at the same time the court will put a stay. ठीक है? Stay can be at any stage of the proceeding. Now another thing is, that is waiver of this right. For example, both the parties decides that we don't want the court to apply section 10 on our proceeding. ठीक है? So this right to waive section 10 is given to the parties. So if both the parties are saying to the court that, see, we want you to proceed with the trial, then the court has no way except inherent power that we are going to discuss. Generally the court has to discuss the thing to proceed with the trial. The court will do, but at the risk of the parties. So whatever be the conclusion, court will not be responsible like this. Anyways, so the right under section 10 can be waived by the parties. ठीक है? Also the stay can be at any stage. Matter in issue मैंने आप लोग को बता दिया है, सब बता दिया है. Now talk about inherent power of the civil code. Firstly, we have this concept of inherent power under section 151 of Code of Civil Procedure 1908. Okay, for example, if you have studied Constitution of India, for complete justice, section 141 or 142, for complete justice the judge may use inherent power. ठीक है, ये concept है. Likewise in CPC we have this concept that in order to provide justice the judge may use the inherent power where no explicit provisions are mentioned. If something is clearly mentioned in CPC, no need to go for inherent power. Inherent powers are used by the code when there is no guidance by the written code, है ना, in CPC specifically. So inherent power, the role of inherent power in section 10 is when the section 10 is getting fully applied, that is all the ingredient of section 10 is fully applied, the court cannot take the recourse of inherent power section 151, but the court has to apply section 10, that is court has to put a hold on this present instituted suit. But where the section 10 is not applicable fully, where the section 10 is not applicable, that is maybe the matters are overlapping. ठीक है, हमने बताया था that again A is instituting a suit for the same property but now with the different subject matter but same transaction only. So what the court can do, court can, in the case of overlapping of matters, court can use inherent power and ask the party that I am using section 10 even though section 10 is not applicable. Okay, because section 10 is only applicable when the entire matter in issue is same. When it is overlapping, the section 10 is not applicable. But with the use of inherent power, the court can say that even in overlapping matter, I am applying section 10 using my inherent power and you go and add this matter also to your previously instituted suit. ऐसे नहीं इतना बड़ा ट्रांजैक्शन है, थोड़ा लेके तुम लोग 15 डिस्ट्रिक्ट कोर्ट में चले जाओ. Understanding? You just consolidate all your dispute, consolidate all your cause of action if they are part of same transaction. Understanding? It's not like for 1 month rent you are going to that court, for another month rent you are coming here, for 1 year rent you are going there. Please don't do this. It is just waste of your time as well as of ours. है ना? तो in such matter where section 10 is not technically applicable, court can use their inherent power and apply it. ठीक है? So this is about inherent power and this is not what I am saying, but it was held in the case of Shetty versus Girdhar. Please note it down. Shetty versus Girdhar, AIR 1982. AIR 1982. Please just listen carefully. When there is a case for application of section 10, recourse to the inherent power under section 151 is not justified. It is like you have to apply section 10. You cannot take recourse of section 151. However, where the provision of section 10 do not strictly apply, the court has inherent power to stay a suit in the ends of justice. ठीक है? तो inherent power कभी हो सकता है, कभी नहीं हो सकता है. One thing more, that is the last thing. What is the status of the decree passed by the court in those matters, in those cases where section 10 was applicable? So it may happen that court during the whole trial did not notice, did not come to knowledge that this suit is already previously instituted. It may happen. ठीक है? In such matter, you cannot say that the decree passed by the court is invalid. ठीक है? The decree is not, or you may write this sentence because this is kind of very important one. Give me a minute. A decree passed in contravention of section 10 is not a nullity. It's a valid decree. It's not an invalid decree. ठीक है? Because if the court knows, then it will definitely not proceed with the trial. It may be because of some negligence, that is after taking due care and caution. ठीक है? So it is not nullity, it is valid for execution. It cannot be disregarded for execution. And with this, our section 10, that is res subjudice, is over. In our next lecture, we will talk about res judicata. Thank you.